Well, hey everyone. You never know when an office hour is going to happen, do you? It's your old pal, Professor McLeroy. Hey, so I wanted to wrap up the series that I've been doing on using alternative dispute resolution methods in real estate. So previously we've talked about ADR in general, negotiation, mediation, and today I want to talk about arbitration and how that works in the real estate space. Yeah, and after this, I plan to move on to some contracts talk, some hot contracts talk, and everyone's talking about contracts. I've got a lot of new and revised contracts to talk about here in the great state of Texas. So absolutely looking forward to doing that. But yeah, let's talk a bit about arbitration. So as a reminder, mediation is where you have a neutral third party, who's the mediator, who helps you're essentially facilitating negotiation between the parties that are having a dispute. So that is, you're using your classical negotiation skills, but you're kind of using them both ways, right? It's not like a situation where you're representing your client and trying to get them the best deal. You're trying to get the parties to find the best deal for themselves as a mediator. In arbitration, rather, it is a little bit different. In arbitration, we have a situation where we want our mediator, sorry, it's not a mediator anymore at this point, it's an arbitrator, or neutral third party, the arbitrator. We want them to make a decision. So in every other kind of dispute resolution, it is about helping the parties reach a resolution themselves. In arbitration, it's out of the hands of the parties to a certain extent. I'll explain some ways in which that's not necessarily the case. But they're putting the matter in the hands of an arbitrator, and it's then the arbitrator's job to render a decision. So let's talk about a definition for arbitration: a forum in which each and counsel for the party present the position of the party before an impartial third party who renders a specific award. All right, so there's a lot of parties involved in this. So arbitrations can come in a lot of different flavors. You can have arbitrations where the parties have attorneys working for them. You can have arbitrations where the parties have non-attorney representatives for them, speaking on their behalf. Or you could have parties that are essentially pro se, that are representing themselves. But here, the general idea is, it is an impartial third party who's the arbitrator. It's presented with evidence by the parties to the dispute, and then renders a specific award. So that term specific award, very important. It's not going to be something just like, oh, everybody get along, or learn to, work out your disputes better. No, it's party A gets this, party B gets this. Right? Importantly, with arbitration, it can be binding or non-binding. Binding means that the parties have contractually agreed that whatever the arbitrator decides will go. Now, that's not necessarily like a carte blanche statement. It's not, I'll make some statements and they're not going to be 100% true 100% of the time, right? But generally, as long as the arbitrator is acting within the four walls of the agreement, the arbitration agreement that the parties have signed, then if the parties have agreed beforehand that it is binding, then it will bind the parties to that agreement. You can then take a binding award from an arbitrator pursuant to an agreement previously made. You could take that down to a court in order to file it and have a judge enforce it if you wanted. Non-binding arbitration is more like an advisory opinion. It is not necessarily, well, by its nature, it's non-binding. It is not necessarily binding on the parties, but it can be very valuable for a variety of reasons. One is, it might give a good idea of what would happen if the parties were to take a dispute to court, or to take it to binding arbitration, for that matter. Parties could have a situation where they have a binding arbitration clause in a contract, but they might also decide, you know what, let's do a test run on this, and we'll see how our arguments play before an arbitrator. We'll see what evidence sways this arbitrator. You could do this a variety of ways, absolutely. So this is one feature of arbitration that is important to note, that it is really flexible. But this it shares with other forms of ADR: flexibility, adaptability, cost, and time effectiveness when compared to litigation. This is all true about arbitration. So we'll talk a bit about more here in a second. All right, so what arbitration is not, it is not a trial. Often what I've seen is you'll have parties to an arbitration, whether those parties are like an actual party, like someone who's in arbitration. We don't use defendant and uh, you know prosecutor. We use complainant and respondent in an arbitration, right? So I've had situations where either the complainant or the respondent are attorneys, and they're used to dealing with trial stuff, right? They're used to dealing with the rules of civil procedure. Um, so they tend to overdo some things when it comes to arbitration. They tend to go a little bit what I would consider farther than necessary, just because they're used to the way courts and trials run. So an arbitration is not a trial. It has a lot of the same features, right? You present evidence to an impartial party who renders a decision. A trial sounds a lot like that, but trials also have um, all these other components to them that arbitrations typically wouldn't have. But similarly, an arbitration is not completely devoid of all features of civil litigation. Uh, Arbitrations can and do have discovery processes, a formalized method for obtaining evidence that's going to be used. Um, as part of discovery, an arbitration could have subpoenas, for example, which are judicially enforceable. Um, each state and federally as well, there are general arbitration acts that set out these kinds of guidelines and rules and restrictions on what is allowed and what isn't. So generally there is an arbitration, this idea that you are permitted to go through a discovery process. But again, this is something that the parties can and often do decide amongst themselves prior to commencing with the arbitration. So as I promised earlier, we'll talk about that a bit more. So I mentioned discovery. What else do we have? Swearing in of witnesses. We have that in arbitration. I've been in arbitrations where there is, recordings. We wouldn't call it a court reporter, right? But a record is being taken of all of the evidence being presented. As far as evidence, again, I say normal rules apply, but that is in court. You wouldn't have like surprise evidence like you would on on a TV show or a movie, for example. Same thing with an arbitration. When I'm doing arbitrations, one of my rules is I want to see everything in advance, and the other party should see everything in advance as well. So the idea is each party is exchanging and presenting me with the evidence they plan to present at the arbitration ahead of time. That way, I get a look at it. Each of them gets a look at it, and by seeing what they're going to present and what the opposing side is going to present, that gives them an opportunity to help build their argument. That also gives them an opportunity frequently to provide follow-up evidence. Only when I'm live here would I forget the term for when you provide rebuttal evidence, that you would give them an opportunity to provide rebuttal evidence. Yeah, I find that sometimes when I'm in class too. I'm like, I've said this word a bunch of times, and I just can't think of it right now, and it's in my notes somewhere, but then I'd have to dig for it. Everyone's staring at me. It's fine, though. Right now, we only have one person watching. I don't have to worry about too many people staring at me. That's okay. So an arbitration is also not a forum for an arbitrator to arbitrarily impose their will on other parties. So in order for an arbitration agreement to be enforceable, it does need to be, I mentioned this before, the idea of four walls. The agreements that create the arbitration, that have created the situation that needs to be arbitrated, and the agreement that allows the party to arbitrate, and whatever else they sign pursuant to the arbitration, provides the boundaries for what is allowed. So, for example, in an arbitration related to property tax valuation, essentially, I get to pick the value of the property as of January 1st of the taxable year. Okay, but I don't have the ability, for example, to instruct the appraisal district on how they should handle certain matters. Right. I've had parties inside a property tax arbitration ask me before, the appraisal district needs to do this differently, or they're doing this wrong, and you need to tell them to stop it. And I will make a point of telling the person saying that, hey, I appreciate that you think that, and that you have a lot of passion around this matter, but I think it's worth noting that my authority here is statutorily limited to determining your property's value as of January 1st. That's what I got. I can't compel the appraisal district to do things. I can't compel you to do things. Again, beyond normal things like enforcing discovery motions, for example. It's also not a process to what's called divide the baby. So there's a classic idea that all arbitrators do is, well, one party wants $1 million, the other party wants $500,000, so they split down the middle and say 250,000, right? It's not simply a process to determine a number. Now, there's cases where it is, right? There's situations where I'm, especially with property tax arbitration, where literally my job is just to assign a value. So I'm not coming up with new and exciting methods for doing things. But there are arbitrations and arbitration venues in which you can have as remedies, specific performance, for example. So you need to do this. So it is often in an arbitration, the arbitrator will often have the ability to kind of think outside of the box when it comes to what they are able to do with their determination. That is especially true, I think, in scenario like labor management arbitration, where you might not be able to, as an arbitrator in one particular case, you might not be able to say, you need to stop doing this. But what you can do in a written out opinion, along with your ruling, is to say, because the agreement says this and the parties were doing this, I am now doing this in response. So kind of the idea is that if the parties continue to do this and this, my response, and probably the response of other arbitrators who are looking at similar cases, will be to do this, right? So that is often a kind of power the arbitrator has, is to create this written record to justify what they're doing and to lay out the framework for other arbitrators in similar circumstances. So from that perspective, it's a little bit like case law, especially for cases that are published under like federal labor management guidelines, for example. So that's something to keep in mind. This is not something I've personally done. That's one of my kind of on the horizon situations, and I've gone to some conferences and talked to some people about it. It's something I might potentially want to get into in the future. But yeah, it's at a minimum, when I go to those kinds of conferences or seminars, I do learn a lot about arbitration, even if it isn't specific to real estate. I've picked up a lot of really good information from that. Specifically how to handle certain pre-hearing motions, for example. I was doing property tax arbitration for years and years before I got assigned a case, and there was a little note with it, and it said, hey, we're not sure if this arbitration request was filed in a timely manner within what's allowed by statute. So before the case proceeds, the arbitrator needs to hear arguments for and against the idea that the case was properly filed, and then decide if it was properly filed, and if so, then they can proceed, move forward with the hearing, and if not, they can dismiss it as being improperly filed. And I was like, whoa, nothing in any of the training that we've gotten for property tax arbitration has prepared us for that. However, talk like that has been absolutely rampant at other arbitration conferences that I've been to. So I felt well prepared for that, is the good news, but I had to be kind of well outside my normal comfort zone in order for that to happen. Let's talk a little bit more about arbitration. Selection and role of the arbitrator. So typically arbitration will come in two different flavors. One is the use of a single arbitrator, and the other is a panel of three arbitrators, right? So typically those are the options. I've not heard of. Now, the whole point of not wanting an even number of arbitrators is you don't want there to be a tie on the final vote, right? So you want an odd number of arbitrators, and I've really never heard of more than three. So it's usually going to be one or three. The arbitration agreement will typically detail the method of appointing arbitrators. So I got contacted a few months back by by two parties. I don't want to go into too much detail here. Two parties that had an agreement with each other, and it said that if there was a disagreement about their agreement, that that disagreement, instead of being filed in court, would go to arbitration. They would mutually select an arbitrator, and that arbitrator needed to be experienced in dispute resolution and be licensed as a real estate broker in the state where the property is located. All right. So right away, there is a method for appointing an arbitrator. That is mutual selection, and they gave the criteria for the arbitrators as well. Right. So I've seen agreements that state that the arbitrator will be someone on the AAA roster, American Arbitration Association. If it's a construction dispute, they might say they will select a from the AAA construction roster. Plenty of agreements state that the arbitrator will be an attorney, retired judge, someone on the FMCS, that's Federal Mediation and Conciliation Service, someone who's a designee National Academy of Arbitrators. There's a million ways of determining who the arbitrator is going to be. Now, as far as that's their qualifications. Now, as far as the actual appointment, when there's one arbitrator, typically the rule is the parties have to mutually agree. Sometimes that's fairly easy, right? Especially if um, in this case, one party reached out to me, said, "Hey, would you be willing to do this?" Pursuant to the other party, looking at your CV and agreeing, I said, "Sure." But you could have situations where, and the other party did agree in this case, but you could have situations where the parties are getting along so poorly that they are going to have a hard time even agreeing on an arbitrator, right? So sometimes there's kind of a fallback scenario for that, and one example of that comes from the Technical Arbitration Act, where if the parties can't agree on an arbitrator, they can ask a state district court judge to appoint an arbitrator. Say, "Hey, Judge so-and-so," just a filing to the court, "Hey, Judge so-and-so, we're having a dispute, and under the General Arbitration Act, since we can't agree on a arbitrator, can you appoint one for us?" "Sure thing, part of my job," says the judge. I've also seen scenarios where if it's going to be heard by a 3-person panel, that each party can appoint one arbitrator, and then those 2 arbitrators will jointly appoint a 3rd arbitrator. So if you're appointing 2 people who are pretty, experienced and conversant in arbitration, it is probably not out of the realm of possibility that they will run in similar enough circles that they know someone that jointly to be the 3rd arbitrator in the case. Once appointed, the arbitrator's role is to conduct the arbitration in a fair and equitable manner according to the rules specified by the parties and to provide a written award within the specified time period. So this is an interesting case, interesting detail about arbitration. That is the rules specified by the parties. You heard that right. So if you were just to someone in small claims court or state district, whatever, they already have rules. They already know the rules that they go by, the rules of civil procedure, right? That's pretty standard. So in that case, you don't have to come up with new rules because there are existing rules, and generally the judge does not have time to come up with special rules just for you. Arbitration, however, is different. The parties can create their own rules. Now, sometimes the rules are already created, essentially. So, for example, I'm a panelist for FINRA, the Financial Industry Regulatory Authority. If 2 parties are entering into an arbitration pursuant to FINRA rules, those rules already exist, so they can look it up and they can see the FINRA rules that are on the books, right? Property tax arbitrations in Texas, those are governed by rules. Those rules are set out in statute. Those rules are set out by the state comptroller. Now, even those rules are not exhaustive, right? They will often say the arbitrator will decide on the time and manner of the hearing and the rules for the hearing, right? Which is a rule, but then the arbitrator has to create more rules to go with. But typically, the arbitrators have done this before in other forums, and they have some general ideas of rules that they can use. The ad hoc arbitration that I mentioned from earlier this year, their agreement did not specify rules. So what I did was I pulled up rules that I typically use for property tax arbitrations. I pulled up some rules from some other panels, like AAA real estate panels, for example. And I just looked at a bunch of different rules for real estate related arbitrations, and I kind of cherry picked. And I got some information from the parties as well. I said, all right, what kind of dispute are we talking about here? What's the basic idea? Okay. How many days do you think each of you will need to make your case, right? And I think for each of them, it was like half a day. we can do it in half a day. Okay, so we'll schedule it for a single day. It's easy. With FINRA cases, those hearings tend to be scheduled for 1 to 2 weeks, sometimes more if it's sufficiently complex or it's a large group. They don't call them class action, but that's the arbitration equivalent of a class action, right? Yeah, so that's the shortest FINRA hearing I've ever been in was 3 days, 3.5, not quite a full week, but yeah. So yeah, that's a neat thing when the parties can create their own rules. So yeah, I asked the parties, okay, what's going to be the amount of time required? Do you foresee the need for formal discovery, or do you already have all of the evidence that you need to present your case? Essentially, can you present your own case based on your own evidence, or are you going to need the other party to turn over evidence in order to uh, present your case? And in this particular instance, both the parties said, um, I think I have enough evidence. But then the respondent said, but I will say, if I don't have evidence about this XYZ issue and I really like to discuss it. So how would we handle that? And I looked at that, and what I said was, this is pretty honest given the parameters of the dispute. I said, what I will say, just from my perspective as the person deciding the matter, if both parties go through their evidence presentations and the other party does not present this kind of evidence that you're asking about right now, I'm just letting both parties know ahead of time, I would draw a negative inference from that. And you can say that as an arbitrator. You can say that something that was not presented, that you would draw a negative inference from that. That is, you would assume that they were hiding something because you view that as being a key component of the matter in dispute, right? Yes. So you're providing conduct the hearing in a fair and equitable manner. That fairness and equity is also key. And some people might take that as like, well, they need to have equal time. To some degree, true, although realistically, taking the time that he needs to make their case, that could be different amounts of time, right? Time wouldn't necessarily result in a fair and equitable treatment in the overall conduct of the case. You could also look at fair and equitable from a perspective of, let's say on one side, you had an investment firm that had a team of lawyers, okay? And on the other side, you had a complainant who was pro se, doesn't have a representative, doesn't have an attorney. Either they couldn't afford one, or they thought they could do it themselves. Seen both. And in a case like that, where one side has an army of lawyers and one side is pro se, fair and equitable could sometimes be, you wouldn't want to help the pro se part, but you want to make sure that they are asking the right questions and that you, as an arbitrator, are getting the information you need to make an informed decision. So, for example, normally in an arbitration, each party is going to tell you the information they think you need to know in order to make a decision, right? But I've had situations where the parties present their evidence, and I look at what they presented, and I think to myself, I don't feel like I have the evidence I need to make a decision in this case. So what will happen then I would call this in the name of fairness and equity. I would then say, okay, appreciate the evidence everyone submitted. I have some questions, and I would start asking questions. If those to answer that question, I would need to get you some information. Great. What I'm going to do after the hearing is I'm going to send a notice out to everyone saying, based on our hearing, I want some additional information from one or both parties. Here's the information I want. Here's the deadline you have to submit it to me with a copy to the other party, right? So that sometimes fairness and equity means sitting back and giving the parties space to do their thing. Other times, fairness and equity means taking a little more of a firm hand, asking questions, requesting additional information so that you really have the information you need. Because as an arbitrator, what you don't want is to get through the hearing and to receive all the evidence and you close it out and you say, that's great. I'll have my order issued to you within 20 days or whatever. And then you start to read and you think, oh my goodness, there is not enough here. I don't have the information I need. That's poor It's either bad preparation or just bad case management work on the part of the arbitrator. In that case, that's what you don't want. Then the other part from conducting a hearing is the arbitrator is to provide a written award within a specified time period. We'll talk a bit about the arbitration award here in a minute, but every agreement will typically have a period in which the arbitrator needs to render their decision. And if the agreement doesn't have one, then that's something the arbitrator should discuss upfront with the parties when they are putting together the arbitration rules and procedures. Let's talk a little bit about confidentiality